Welcome to our next instalment of the Ansons podcast. Today I'm joined by Martin de Ridder, our MD and one of our litigators, and we're going to do a whistle-stop tour through insolvency law and what that means, the different forms of it, both for individuals and for corporates, and what that means, what the processes look like, and what you might expect to find in either area. We're going to start with the individual. So you and I, the natural person, the individual, and there's two main areas. We've got bankruptcy and we've got IVAs or individual voluntary arrangements. Do you want to explain a bit about what a bankruptcy is so that anybody watching this can understand what we're talking about?
I mean, the starting point for both corporate and individuals insolvency, in effect, the definitions for both is really that you cannot pay your debts as they fall due, or a cash flow, a substantial cash flow issue, or that your liabilities are significantly more than your assets to the point that you're unable to sort of keep funding your liabilities, and therefore a process will be initiated either by you or by somebody else to put you into a formal insolvency process. Now, the formal process for individuals is called, and it's a familiar term I think for people, is bankruptcy. And bankruptcy can either be initiated by somebody you owe money to, one of your creditors, or it can be initiated, and often is initiated, by an individual themselves. Either way, the route into it is via what's called a bankruptcy petition. It's a short piece of paper, 3 or 4 pages long. It explains, on there you've got to put various bits of personal information on there, and name, address, that sort of stuff. And if you are a creditor petitioning for somebody else's bankruptcy, it will say what the debt is there. And if it's your own, you may well list your overall total liabilities to your different creditors, typically what we call your unsecured creditors. So in other words, that's not your mortgage company, that's credit cards, that's people who you owe money to generally, bank loans that are unsecured, catalogues, credit cards, all of that sort of debt that somebody can build up.
Just for clarity, what's the difference between a secured debt and an unsecured debt?
So a secured debt has got security, typically in the form of a mortgage or a charge on property. So your classic secured debt is your mortgage. Classic unsecured debt might be something like a loan you've taken out to buy a car or do some home improvements, but hasn't got a mortgage or a charge attached to it.
And what's the advantage to either starting a bankruptcy, let's take it one at a time, to starting a bankruptcy yourself? What's the purpose of it? Why would you do it?
I think that often what happens is when somebody gets themselves into a bad situation and a debt has really mounted up to the point at which actually no matter what they do, they're just never going to be able to clear it. And interest is compounding upon interest, and ultimately the individual a lot of the time in credit terms just can't ever sort of see a way of clearing this debt in any reasonable timescale. And I think that somebody, if they've got unsecured debt and it's going to take them more than, I don't know, something like 5 years to get that cleared or longer, I think it definitely does become an option for you. And in those circumstances, you take legal advice, you take advice from debt counselling charities, CAB. Often they will say, look, in personal bankruptcy is an option. It does have consequences. You are declared bankrupt relatively quickly, typically a couple of months. I mean, ongoing theme on these podcasts is, unfortunately, delays in the civil courts at the moment. And whilst, I would have used to have said you'll be able to get an appointment in about 6 weeks, and that's stretching now certainly into 2 and 3 and 4 months, unfortunately. Once you are declared bankrupt, you do shortly after that have to have a meeting with somebody who will be appointed by the court on behalf of the official receiver, which is the government, who will be appointed as your trustee in bankruptcy, and their job is to oversee your bankruptcy, for want of a better word, or oversee the process. You will have to answer questions like almost like a job application form type about what all of those debts are and what assets you might have, which could be perhaps sold to pay off some of those debts. He will then typically work out a sum of money that you are able to afford to pay back over a period of time. That sum of money is always something that is affordable. It's always something, it could be as low as sort of £50 or £100 a month or something along those lines, which won't really pay off much of the debt. But you don't need to worry about that, because once you're bankrupt, in effect, you are asked to make that contribution typically for a 12-month period. However, at the end of your bankruptcy, all of your debts are extinguished, and as if you are allowed to start again from fresh, and you don't owe any money to anybody at the end of your bankruptcy. Now, that doesn't mean there aren't consequences to bankruptcy, but the good thing, the positive thing about bankruptcy is at the end of that process, you have got a clean piece of paper. You own no unsecured debts to anyone.
So I guess it's got two positives, doesn't it? One is it clears the debt. It removes that obligation to repay. But in the shorter term, for those who are struggling, particularly if they're being put under pressure from creditors, it also stops the creditors from constantly, not harassing, but putting pressure on that person. Because, and it takes that level of pressure away from the individual, doesn't it?
They will stop writing to you once you are able to tell them that you've been declared bankrupt. They will. You should not have any contact from any of them, and indeed, actually, it would be unlawful for them to keep harassing you, the other side of a trustee in bankruptcy being appointed. And typically, if you are experiencing that, your trustee will write to them and say, you can have a claim in this bankruptcy, but you need to leave that individual alone. It can have some consequences, of course, biggest one being in terms of your credit and credit rating. Once you are declared bankrupt, that's going to have a long effect on your ability to obtain credit on favourable terms. During your bankruptcy yourself, you're not actually allowed to have your own personal bank account. So there's some inconvenience there, and you've got somebody up to a point looking over your shoulder. But in my experience, most people who are worried about bankruptcy and bankruptcy as an option, virtually everyone I've ever met or who has done that has always said to me, the best thing I ever did in my life. Just allowed me to just completely put in a box that difficult period of my life financially, get it cleaned off and move on. There are some other complications because, of course, in certain professions, I think our own profession being one of them, you can't practice whilst you can't be a practicing certificate solicitor with a bankruptcy.
I think they've changed it, haven't they, for us recently in the last few years?
Right.
You can, but you have to be notified and you're not allowed to touch client accounts and the like and deal with money. But yeah, certainly there are professions.
MPs and different things like that. I think certain professions.
Yeah, accountants, financial regulatory types, anything that's got money where there's a temptation there. But yeah, so there's an implication.
So clearly, if you've got one of those type of jobs, you might need to look at some of the other options, which we'll come on to in a second. But I have to say, when you've got to the point where you just don't see financially any, you just aren't able to make any kind of dent in the level of the debts. Getting some advice and putting forward, look, should I be thinking about bankruptcy? Is worth doing. Again, most people who I know, and I know both personally and professionally, people who've done it, they've always, certainly a couple of years after it's occurred, said, I wish I'd done that years ago.
And of course, the other group that might not be able to do it would have to think carefully are directors, aren't they, of companies?
You can't be a serving director, and so and certainly if it's your own business, you're the 100% shareholder. That's going to cause you a problem for sure. But as I say, the process, there's a meeting or two with the trustee in bankruptcy, and up to a point, admin wise, that should, provided you cooperate, that should be it. If you have got property such as a house, the trustee in bankruptcy will in effect own your equity, and that will transfer over to the trustee in bankruptcy. So if you own property with my wife, when I was declared bankrupt, my share of the equity in the house, 50% of that equity would actually then belong to the trustee. Often what we see is the trustee will be prepared to sell that interest in the property if the wife can raise some money, and not normally the full value, but can raise some money towards paying that off. Then you're not left in a situation where you will necessarily lose your house if you are declared bankrupt. And indeed, I would go so far as to say I probably rarely see that happen these days.
I think that's right. And in terms of what they can and can't do, I mean, so obviously you're going to sell assets. It's about the estate, if you like, your bankrupt estate being sold to pay off your creditors as much as you can. But generally they won't touch certain things, will they? So they often won't take the roof from over their head, subject to what we've just talked about.
They're not interested. They're not interested in televisions and video recorders. They might be interested in very expensive jewellery that you own, or Rolex watch or something like that. If you've got a Bankruptcy painting holding, on the wall, they might be interested in something along those lines. But you're probably not going to have a Bankruptcy painting holding on your wall. It would be painted onto the wall, I guess.
Possibly.
But if you've got, it's something that's high value and sort of readily sellable, they might be interested in trying to get a return for because that's their job really, to get a return for the creditors. They won't be paying the creditors every penny in the pound that is owed to them, but to make something, to cover their own costs and to make something of a return.
Equally, they're not going to go for things like tools of the trade generally.
No. So if you've got, you're a mechanic and you've got a snap-on toolbox full of tools, they're not typically going to be interested in that. Or a butcher's. Butcher's been my sort of analogy on this podcast recently. But if a butcher's got a sort of set of knives that are the tools of their trade, they're not going to be taking those off them.
Which makes sense, because to a degree you want that person to still work so they can put money back into the bankrupt estate.
They're typically they're only really, in terms of personal property, looking at something that you have got that is very readily sellable and of high value. If you've got something like that, then that a trustee would be interested in taking that off you and selling it for the benefit of the creditors. But it would have to be, as I say, the days of them going after televisions and even cars, to be quite frank, which people will need to get to work. They typically do not try and make somebody sell their car. Again, if it was a Ferrari,
it'd be a different story.
It would be a different story. But for most people's day-to-day vehicle that they use for their commute, they're not going to be interested in taking that off their hands.
We've talked about bankruptcy from an individual perspective, and we'll come back to what you might do as an individual in a moment again. But it's probably a good point, because you've already mentioned that there are two routes into the bankruptcy. One is you put yourself there, and the other is that somebody else can put you there. If you are owed money, why might you think about putting somebody into bankruptcy?
Well, in effect, even though officially it's not meant to be used as a debt collection tactic, it's a debt collection tactic. Now, you don't really want to get that person declared bankrupt unless they're somebody who is literally causing you ongoing financial harm by being a non-bankrupt person, But for them, I'm trying to think of somebody like a gambling addict who was continually sort of spending families' monies or something along those lines, or almost like a financial safeguarding issue. But if you are a creditor and somebody owes you money, somebody in business or something along those lines, you don't really want them to declare themselves, but you don't want to make them bankrupt, because if they go bankrupt, the chances of you getting much of a return on your money is probably relatively low. But because people generally, notwithstanding what I said, do not want to be made bankrupt, the threat of a petition, either by you writing to them or you serving on them something that's known as a statutory demand, which is in effect a 21-day notice that unless you pay this debt, you're going to petition for their bankruptcy. They can often be quite effective tools of forcing the hand and forcing them to pay you, maybe lending some money off a relative, or getting somebody to pay a debt that's fallen due. Now, strictly, and this applies come on to corporate insolvencies, the law does say, the case law says that you're not meant to use insolvency as a debt collection tactic, that it's a collective remedy, and that's and that it isn't a debt collection.
Yeah, I think the reference is something like not to be used as a blunt instrument of debt collection, isn't it? Is the quote from the
and you'll find certainly if you take advice from ourselves, we would only advocate it if the debt that was due and owing was clear evidence of the person just can't pay or won't pay, right? That if there's any kind of dispute in relation to the debt, we would steer a long way clear of using insolvency as a methodology of trying to collect that debt in.
You do see this quite frequently, and probably more frequently than we'd like, is where people do come and say, oh, I want to make that person bankrupt, and they want to use it as a debt collection tool. But that has its own difficulties.
Well, yeah. I mean, let's just be clear. If you succeed in your aim of making that person bankrupt, if you get 5p for every £100 that they owe you, you've probably done quite well.
Yeah, and if you're doing it, who's paying the costs of it?
Well, if you're petitioning somebody else's bankruptcy, the petition fee, is yours to bear.
And when you do that in the court, you're not only paying the court fee, you're also putting a deposit down on the insolvency practitioner's fees, don't you? Generally?
Yeah, you were generally doing that, and there's a proper. You will typically need a lawyer or some paid professional to go through that process for you. You've got to file evidence that you've served the proceedings, to serve the paperwork. You've got to, there's all sorts of certificates and all of the insolvency processes that you've got to. It's an expensive game. I'm not saying that you shouldn't use it. It definitely is a tool in the armoury. However, at the same time, I think that it's to be used sparingly and only in sort of certain circumstances, really.
And there's risks, isn't there? Whereas where you can sue somebody, you might get the figure wrong in your pleadings, because instead of owing you £5,000, they owed you 4.5. Probably. But if you get it wrong in an insolvency proceedings, that's really risky, isn't it? So, for example, if we're suing somebody because we've got to bring a claim to get a judgment debt, and we put in, let's say, £6,000 on the claim form, but it turns out that they're owed £5,500, it's not the end of the world, because you'll recover something, and the court has its discretion to just substitute in the value and make a judgment for what you're owed. You can't do that, can you, with a stat demand or an insolvency?
Yeah, because if you get the number has to be spot on right as an undisputed debt, because if you've got it wrong, I mean, a judge will often use that as a reason for chucking out the demand or setting aside the statutory demand. Listen, I mean, if you get one of these documents, and whether you want to avoid being declared bankrupt, or you think there's a dispute, you do need to quickly. It's not the sort of paperwork that you can ignore. Certainly, there's any letter that threatens bankruptcy, or any the formal statutory demand document, which will say statutory demand on it, you do very quickly, within days, need to be speaking to a lawyer to get that sorted out for you. Make sure that either the debt is paid, or that if there is a valid dispute, that dispute is put forward. Typically, in those circumstances, if the creditor is well advised, they will withdraw their demand. If they won't, you can apply to court to have the demand set aside, and if it's got as far as the petition, you can get an order from the court to throw out the bankruptcy petition.
And that's expensive if you get it wrong, isn't it?
It's expensive, and also, I mean, I've seen a couple of times this year people get themselves into a mess and get declared bankrupt, even though they've got lots of assets. There was from a tax bill to a large creditor that was owed a lot of money. And even though their family was reasonably wealthy, or there were certain things that could be done to avoid that situation, they got declared bankrupt. Once you've been declared bankrupt, you can apply for what's known as an annulment. But that, again, is an expensive process, because to get an annulment, you have to then pay every single one of your unsecured creditors off. There's a process that you have to go through with the official receiver, and if anyone's appointed as a trustee in bankruptcy, with them. And there's typically a court hearing to get the annulment through. It wouldn't be outside the realms of possibility that just in terms of professional costs alone, it might cost you somewhere in the region of £5,000 to £10,000 to get that annulment through.
And in the meantime, your credit's affected, so the credit you might have had open to you is probably not going to be there.
It's only going to be really if you can speak to a friend or a relative who's prepared to lend you some of the money. I mean, your bank account typically will be frozen in those circumstances. Well, typically will be frozen in those circumstances. So that's not going to be an avenue if you've got the money in a savings account to sort of clear these debts. Absent with the cooperation of the trustee, again, it gets expensive. Getting that money out to get the creditors paid is going to be tricky on an annulment anyway.
And just to sort of finish off this area, if you've got a case that's been run, be it you're running it against somebody else, or if you've got a case being run against you, what happens if a bankruptcy order's made whilst that's going on?
Well, it will ultimately, in effect, impose a stay of proceedings on those court proceedings. It will stop. It'll press the pause button on the proceedings, and then the combination of if you're pursuing that claim, your lawyers can, in certain circumstances, apply to have the stay of proceedings, the pause button, set aside. However, typically the court will only. It's probably rare and few and far between when a court will allow that to do that, because it is in many cases a pointless exercise, because in terms of you getting any money there, the court will want to if you're just going to be dealt with as an unsecured creditor in the bankruptcy, the court will say, well, there's no point in us setting, if what you're seeking is a money judgment, there's no point in us allowing this stay to be moved. The press play on that video recorder to say the proceedings can go ahead, because there's no financial return. It's slightly different when what you're seeking is a non-monetary claim. If you'd got an injunction for the return of some property, or actually possession type processes to get a house, or some land, to recover some land, in those circumstances, more likely that a court is going to allow you to have that stay of proceedings lifted.
But even then, it's going to put it down initially. So if you've got a hearing that's coming up and you've got that going on, you've got the chance to argue, but most courts will usually give the trustee in bankruptcy a chance to get in, get their feet under the table and get sorted.
And work out how they're going to deal with it. You know, and we've had that happen, several times even in the last 12 months, right?
Yeah.
It's one of the risks always of pursuing claims against people. And before you ever start claim against someone is, are they, in the likelihood that the proceedings run, are they going to be able to afford to keep running the case themselves? Because if they get declared bankrupt, chances are that that's the end of the process, and your claim will be dealt with as a claim in the bankruptcy, as opposed to you getting a judgment.
And it's certainly a tactic that's sometimes used. I know I've seen it, where people say, oh, if you issue this claim, we're going to go bankrupt. And then you have to make a commercial decision, don't you? And
sometimes they're calling you bluff, and sometimes people do call their bluff. Happens several times each year, I would say, in my practice, that you face that situation.
In terms of the individuals, then, we've talked about bankruptcy. What else can they do? What other option is there that they might be able to explore rather than being adjudged bankrupt?
So the main one, I mean, first of all, and perhaps informally, you may just be able to do deals with your creditors. Again, we've got some good people who can help you at Citizens Advice. There are some charities out there who will help you try and negotiate with your creditors, whereby I've seen where a credit card company will tell you what, if you pay us 50% of the £30,000 debt, and you can pay that in one lump sum, we'll forgive the rest, we'll write the rest off, or perhaps if we'll cap the figure at a certain level and we'll allow you to pay by instalments. Mm-hmm. Lots of those deals are often there. I mean, the issue sometimes with doing that on your own, when you're in debt crisis, your mental health can be affected. It's a terrible time in someone's life, and to do the informal type arrangements, it's quite a lot of administrative work for an individual to do, and that's why, again, if you are going to do that, it's not work that we actually as solicitors ourselves, we're not regulated to do that sort of work, but there are organisations out there and charitable organisations that can help you try and see if you can cut deals with a large number or even a small number of unsecured creditors. And I mean, that's, I don't know what I particularly call that. Sometimes somebody might call that a workout, or just, doing deals with those unsecured creditors. And that often is what people will do, probably do that more often than not. However, if that isn't going to work, perhaps there's just too many of them, but bankruptcy is not an option for you because you're worried about you're director of the company and you're worried that you lose your directorship, or you're in a profession that precludes you from practicing, then often what will happen is people will do what's called an IVA, which is an individual voluntary arrangement. And you will typically go and see an insolvency practitioner, and they would be if they're appointed, they become the supervisor of the arrangement, and that they put a deal which, if 60% of the unsecured creditors accept, will be binding on all of them. And that deal typically will either be some kind of arrangement whereby you're selling some property. So the IVA presses pause on everything, you'll sell the property, and then when the property is sold, they'll get paid X in the pound. It's whatever deal that supervisor can do with your creditors. Maybe it's 50% of the equity that's due to you would be then shared between the creditors. Or alternatively, sometimes it's some kind of instalment plan. Sometimes it's a combination of the both. Typically, for that to be attractive, your creditors get to vote on that. Typically, for an IVA to be attractive, it's got to be returning, an improvement than what they would get if you were declared bankrupt. And we see these. We see some creditors adopt a tougher line than others when it comes to approving or disapproving the IVA. I mean, I think there's got to be an attractiveness to them. I think there is sometimes a bit of a bad name for IVAs, and sometimes I've been a little bit disappointed whereby the actual terms are quite tough. There is the level of instalment that you have to pay every month is too high to be affordable to the individual. And perhaps for a while, by robbing Peter to pay Paul, they can afford to pay it, but then something goes wrong and then they have to go bankrupt anyway. And I always feel a little bit frustrated for those individuals, because they would have just been better to have gone bankrupt in the first place, and that everything their debts would have been long since washed clean. Whereas sometimes those IVAs, if they fail after 4 or 5 years, it's a real heartache for the individual concerned, because their debt problems could have been long in the rearview mirror if they've gone down an alternative plan. I think that if you are going to explore that, it's really important. Again, I think people like the Citizens Advice should be your first port of call to perhaps recommend insolvency practitioners. You want a proper qualified insolvency practitioner, regulated typically by the accountants. You tell me what is it? Royal Association of they've got a couple of regulatory bodies, haven't they? Accountants.
You've got the ICAW, isn't it? The chartered, and then
we should know the answers to this, but we don't. But the point is, what you don't just want is some sort of advert that comes up on your Facebook feed because it is an area where unfortunately there are a lot of cowboys out there.
Yeah.
We could always, again, for people who are within our network, for our clients who are facing these difficulties, we would refer you to people that we know and trust, who can assist you and give you an honest appraisal whether an IVA, as opposed to bankruptcy, or as opposed to just speaking to some of your creditors, is the way for you. All of those free options should typically be on the table, and a good person specialising in this area will try and suggest the process that is better for you, as opposed to the one that makes them the most money. And most of certainly the regulated accountants and insolvency practitioners that we would deal with will always give best advice in those circumstances.
Let's move on then from talking about individuals to talking about insolvency in a corporate setting. So do you want to explain to those who are watching what the difference is between the two and the insolvency process rather than the bankruptcy? So
on one level, the difference is not particularly stark. They're very similar. Ultimately, the test for insolvency is the same. Can that company pay its debts as they fall due? And then the other acid test, as it's known, are its liabilities greater than its assets. If a company is in a situation where it falls into either of those two categories, again, there might be a consideration for its directors, its shareholders, to make about putting their company into an insolvency process. And equally, if somebody owes you money and you're concerned about ever getting it back, there is a remedy to petition to have a compulsory process imposed upon that company, a compulsory insolvency process, which would then see the company placed into a forced insolvency situation. And we can come on to the different names and the different types of these processes in a second.
I was going to say that there's a slightly different level, isn't there, in this sense, where it's not bankrupt or insolvent or not bankrupt or insolvent. There's another process in between, isn't there? So do you want to talk through what the insolvency options are for an incorporated?
Well, first off, actually similar to an individual, there is the workaround. There is the doing deals with people that you owe money to, whether that is negotiating time to pay arrangements. You'll often hear that with HMRC, who often is one of the big creditors if monies are owed for VAT or tax. Can you work out a deal with HMRC to pay them out over a period of time? Often, again, that's going to be probably the first thing that you explore. If not, you will consider and take advice upon, and we'll come on to this in a second, the different types of insolvency. The main two routes that people will have heard of, there are others, when you're doing it on a voluntary basis, is a liquidation or an administration.
Okay. Do you want to explain the difference then between a liquidation and an administration?
And I think the clue is in the names of both of them a little bit. So a liquidation is a liquidator is appointed and by the court, and that liquidator, or by the creditors, sorry, because there is a voluntary route into it as well, but a liquidator is appointed and their job is to collect all the assets, sell them and distribute whatever they've got as a dividend effectively to the unsecured creditors of that company.
And what happens to the company at the end of that process?
That company is liquidated, effectively killed off. It will eventually be dissolved, but the company is no more. And we're not wanting to sound this like it's Monty Python and the dead parrot, but that the company ceases to be. It typically will. The process of liquidation will be concluded, and the liquidator will apply a form to fill out to have that company dissolved from the register.
And the liquidation's a cessation of trading, isn't it?
That's it. It's a proper sort of hitting a brick wall in terms of that that company's existence. Yeah, it's the end. Versus an administration, and again I say there's a bit of clue in the name that where some admin occurs. An administrator is appointed. That's the title of the person who's responsible, a person or people, or sometimes it's typically two, who are appointed to run the affairs of the company with a view to, in some form or another, rescuing that company or that business as some kind of going concern, with an outcome that is meant to be better for the unsecured creditors. Now, where we see lots of admins like that is with football clubs. And an administrator is appointed and run that football club for quite a period of time. It happened at Derby County recently, and the idea being that hopefully somebody will come along and buy that company, or it's able to realise assets so that it can leave the administration. So unlike the liquidation where the business sort of and the company smashes into that brick wall and is no more, on an admin you can leave administration, the company can leave administration in one piece if it's able to sort of sell things or release monies that are due to it, and actually continue to trade as if it was never put into that process in the first place. I have to say, the sort of football club type admin, where it goes into admin and then comes out the other side as a legal entity, is relatively rare these days. Often what will happen is that the assets of that company are sold by the administrator to a third party who will typically buy that in another corporate vehicle, and either the company itself will then go into a liquidation process, but it's easier for the business to be rescued in a form via that type of admin, and I see those far more regularly than a company that goes into admin and then gets out of the other side in one piece. It often can be called, and sometimes they get a bad name, a pre-pack, whereby in effect, or at least the implication is that the directors of the company who get together to place the company into the administration try and do some kind of deal whereby they can, via another company, a fresh company if you like, purchase the assets and rise like a phoenix from the flame, and for that to happen almost on the day that the company is placed into the administration, and they sometimes creditors get very annoyed and upset when that happens, quite rightly, particularly if they feel that the deal that's reached by the administrator is not in the best interest of the creditors as a whole. I mean, ultimately, the administrator will need to answer to those creditors and justify the deal that he has struck with them.
And let's be clear, just because something goes into administration doesn't mean it's a pre-pack. It could be a case that the insolvency practitioner tries to run it, doesn't work, realise they can't get it to where they need to, and so then they can sell the assets off either individually or they can set it as a group at that point. And that's perfectly legitimate. It's a way of trying to raise as much money as they can to get back to the creditors, isn't it?
Yeah, no, exactly that. And I think that sometimes people are very cynical, and this sort of pre-pack has got a bad name. Most of the time, most of the insolvency practitioners that we deal with, the sale like that will be a last resort. They're trying to get the best deal for the creditors as a whole, 100%.
And just so that anybody watching this understands what we're talking about, when you're pre-packing, you're leaving all the debts behind in the thing that is insolvent.
Yeah, company one. So if company one goes into the administration, and let's say it owes £1 million of debts, but it owns a warehouse and a fleet of vehicles, the directors of company two will come along with company two, perhaps having raised some money or put some money into company two, and company two will buy the assets but leave the liabilities in company one. So they'll buy that warehouse perhaps out and the fleet of vehicles and run a new business. Company one, the debts remain within company one. However, the money that is raised by that sale should then be distributed amongst the creditors of company one. But company one itself has not got a future. It eventually will be either dissolved straight from the administration or will be placed into a liquidation process.
Okay. And in terms, you've sort of made the analogy of rising like a phoenix, and there are certain people that will come to you and say, "Oh, they've phoenixed this," but phoenixing's quite specific, isn't it?
Go on, you're gonna on this one, Jason. You're gonna need to to tell me what you specifically mean here. Go on.
Okay, so a phoenix phenomenon on an insolvency actually doesn't just mean that company 2 buys the assets and carries on trading with a new business. What you can't do and what people have to be aware of is you can't trade under a name that's similar. You can't use the goodwill of the company that's gone down.
You can expose yourself. Yes, you are banned. You are precluded from using the name. You've got to be very careful with that company too. If it was called MDR Limited, that are my initials, in case anyone hasn't worked it out. Company 2 can't be called MDR Limited. It's got to be called something different.
And something materially different. So it can't even be MDR2 Limited.
No.
And there's a whole series of rules around when the companies are set up. So and the sting in the tail is if anybody's thinking of doing this, what happens is the directors become personally liable for the debts
of Company 1. Of MDR 1's debts, you become personally liable for that. That's correct.
And so you lose the corporate veil, and it can be potentially ruinous from an individual's perspective. So it's always something to have a think about.
It's another one of these things that, if you're wanting to be involved in a company that's going to engage in a rescue process, to take legal advice to make sure that you don't fall, for the pitfalls that will make you subject to a Phoenix type application, typically by the insolvency practitioner to pursue you for phoenixing in effect.
Yeah, absolutely. So moving on, we've talked about administration.
Yep. We've
talked about liquidation.
Yep.
What other processes are available for a company?
There is they can do in the same way. By analogy, you see less and less of that these days, but they can also go into what's known as a CVA, which is the C standing there for company, and that's the equivalent of a sort of workout, a formal workout that's binding on the creditors of the company. I do not see that happening very often these days. They've become rarer, a little bit because the administrations and some forms of the liquidations are better, more effective tools. Well, within a liquidation, we talked about you pursuing a process whereby you then will come on to how you can put a company into liquidation. Within liquidation, there is often what's called a CVL, which is a creditors voluntary liquidation, and that, in effect, the directors of the company and its shareholders will put a proposal out to the creditors. A meeting will get called, and those creditors will vote on the appointment of a liquidator and placing the company into that process. You can have, somebody might have heard of what's called an MVL, which is a members voluntary liquidation, but actually that isn't relevant to what we're talking about today, because to do an MVL, you've got to be solvent. So that's used typically when people are trying to, in effect, end the life of a company, but it's not a situation where people are owed money. And the other types of insolvency process that might affect a company are a receivership, which is typically initiated by the company's secured creditors, the bank, who might have a debenture, which is a form of charge, almost like a corporate mortgage, and they will put the company into administrative receivership. It is very similar to an administration, but they can use their mortgage document because you're in breach of that, because you haven't been paying your regular monthly instalments towards your loan, and they can sometimes freeze your account and, in effect, appoint a receiver over your assets.
And just for clarity, why would they appoint a receiver rather than an administrator?
Well, because they, in effect, straight away, it it freezes their charge. They will have more control over the process of the receivership to collecting the assets, which is what they're entirely interested in. That might be property. That could be, sometimes people will charge their book debts, the people who owe their money, and they will have complete control over that process, the person that they have appointed, and their job will be to collect in those assets, primarily to pay back the debt of the receiver, rather than perhaps the more broad outlook of somebody who's in an administration. The final category, which again I've seen more recently, I hadn't seen in the early part of my career, but then have seen more recently, is an LPA receivership, whereby it's about property, and there's typically it's in relation to a commercial mortgage and a trust. A receiver again is appointed purely. Sometimes the person might not be insolvent themselves, but they haven't been paying what they owe in relation to the property, and that person will be appointed LPA receiver, Law of Property Act receiver, purely to recover that property for the benefit of the person to whom the money is owed.
Okay. And talking about the different parts of the process, we've talked about what they are. How would the company put itself into it?
Well, I think that interestingly, I mean, listen, if a company is faced with financial issues, starting to get the red letters from not paying their debts as they fall due, which is the test of insolvency, starting to get judgments against it, or indeed even before that, what we would say to our clients in those situations is, look, you need to go and get some insolvency advice. And indeed, if you do that, that is what a reasonably prudent director of a company would do. Once you are in financial difficulty as a director, you have got a what's called fiduciary, which means a serious duty, not just as before to your fellow directors and the board and to the company itself and its shareholders, but once you are starting to have financial difficulties, your duty now extends to the creditors of that company. So if you're racking up a load of CCJs, you need to be very, very mindful as a director that just ploughing on and continuing to run this business that is losing money, your obligation, you potentially have got an obligation to act in the best interest. Not potentially, you have got an obligation to act in the best interests of those creditors. So once you are hitting those sorts of issues, you do need to speak to your lawyer. You do need to speak to your accountant, both of whom may suggest that you go and get some insolvency advice. And if you did get that advice, that's one of you're discharging the duty to those creditors by realising that the writing is on the wall and prudently going to obtain some advice from an insolvency practitioner. Now, that insolvency practitioner, again, if it's a good one, will give you the different options and lay it out for you. All of that suite of different types of insolvency processes, if that's the way forward that we've just outlined. And if so advised, you may well, if all of the directors agree, go down a CVL or an administration route. Both of them are open to you. The shareholders do have to be involved if it's the CVL, less so on the administration side. He will advise you what the best, or he or she will advise you what the best process for you to adopt is, and then you will then initiate that. It's typically involving a meeting, filing some documents with Companies House in certain circumstances, depending on the process, with the courts. And there's some paperwork. There's often a cost, and sometimes personally, if the company hasn't got the money, there's a fee to be paid to that insolvency practitioner in relation to their initial advice. And then assuming that the advice is to enter one of the formal processes, the relevant paperwork gets filed, and then the running of the company slips out of the director's hands and moves typically under the responsibility of the insolvency practitioners who are appointed.
And just so that we touch on it, although it could be a discussion in itself.
Yes.
We've already talked about fiduciary duties being very serious, very important. What happens if the directors don't follow that and they do decide that they're going to trade this business and just let it keep losing money? What's the risk? What's the risk of not going and taking that advice and not following an insolvency process?
You run a company, and if you've got a business, you should run it via a company, because you have what you mentioned it earlier, the corporate veil. I mean, it's lovely lawyer's language, but in effect, what that means is you are not personally liable for the debts of your company. And it's fundamentally sort of what stuff like the sort of industrial revolution and the growth of capitalism has been based on, is the limited liability concept. You can run a business, and yes, it might mean that you don't make as much money as you would want if that company fails, but at least your own shirt is not typically on the line. Now, if you run a company, and I think it has to be said, flagrantly run a company into the ground, where it's continuing to trade, when it's absolutely obvious that the company should be entering one of these processes, there is an action that the insolvency practitioner can take against you for wrongful and indeed in certain circumstances fraudulent trading, and that's a personal liability. You can have to pay damages to the company, effectively to its creditors, for wrongfully trading that company when it was obvious and flagrant, and you made creditors' positions worse. If you were selling ice creams and you got 60-day terms on cash and carry, and each day you went out to sell your ice creams, but they weren't selling and they were melting, I guess you'd have to have a pretty rubbish refrigerator if they were melting. So you knew you were losing money. There has to come a point where you've got to stop going to that cash and carry, because you're losing money every day, and it should be obvious to you that you're losing money every day. And if you continue sort of dunderheaded on, just keep making that creditor's position worse because you know you've got your 60-day terms, even though you know that you are losing money, rightly, the insolvency practitioner, whose job it is, part of his job, is to investigate the conduct of the directors, will likely say, hang on, it should have been obvious for you a long time before this company formally went into an insolvency process that you needed to have taken some advice as to what you needed to do and stop the things that are making the creditors' positions much worse.
And if they fail to do that, the directors can also be reported, can't they, to the DTS or BIS or whatever it's going to be called tomorrow.
This is what lawyers like us say, because it's been changed about 16 times. It's the artist formerly known as the DTI, and it was BIS at one point.
Yeah, that's right.
But I don't know what it's called at the moment. Is it called DTI again? Either way, at the end of the process, on every insolvency process, company insolvency process, the liquidator has to file a report, or the insolvency practitioner has to file a report, and often they can, particularly if something like this has occurred, state that recommendations about the conduct of the directors. And I have seen and have acted in relation to prosecutions by BIS, DTI, by the government, let's just call it that, to ban people from, or suspend them from being a director for a period of time of any limited company.
And it can be quite significant, can't it? It could be 6 years, I think.
Yeah, often you know there's sort of plea bargains and whatever that can be done and undertakings given, but it can be costly to you as an individual, but also can stop you if you intend to be a director of a company. It can prevent you from doing that for quite a substantial period of time.
That can be really significant if you've got an entrepreneurial type who's got 5 or 6 other companies. It can stop you in all of them, can't it?
The one company falling over when you've traded it insolvently can have massive consequences, and quite rightly. I mean, often these companies can be run recklessly with regard to the creditors' positions, and I think it's only right that in those circumstances the directors are made to account for it, and there are consequences.
So we've talked about the processes. How do we put a company into liquidation, or administration, if that?
When we're a creditor.
When we're a creditor.
Somebody owes us money. Well, again, like I said, for individuals, in the strictest sense, you're not meant to use insolvency proceedings as a debt collection tactic. However, in circumstances where there's clearly an undisputed debt and you are a creditor, you've got a judgment against a company, you are able to place that company into a compulsory process. Typically, it will be a winding up petition, which leads to compulsory liquidation. Now, that can be based just purely on you've got your judgment, or there's a debt that the company's not said anything about, and you write to the directors and say this debt is undisputed. Clearly, you're not paying it, and that's evidence that's evidence that your company cannot pay its debts as they fall due, i.e. it's insolvent. Unless you pay us, we're going to start an insolvency process off. And also, again, similar to an individual, you can use a statutory demand document which gives them 21 days to pay, but is formally served upon them and often has the effect of a proper formal document, just as opposed to just another lawyer's letter. Often can have served by a bailiff, can often have a bit more of an impact to get their attention to realise that they don't pay this debt that is set out in the demand. They unfortunately are going to be entered into an insolvency process, a compulsory winding up process against their will. They're the typical compulsory routes in. Clearly, we've touched upon secured creditors have got receivership options and administrative receivership options.
And these formal processes can have a bit more weight, can't they? Because even if you present and if you get paid, your other creditors can step in, can't they, as well?
They can substitute. They can take over the process. There's a bit of an administrative faff to doing that, but sure, yeah, because they're a collective remedy. Another creditor, because when you go through a compulsory winding up petition, when you go down that route, once that's issued, it will part of the process that you have to follow as that creditor that's owed the money is you have to advertise it, and that's advertised and it will appear online and on some of the credit searches that people monitor, the referencing agencies. And another creditor who's owed money may at that point say, hang on, I'm owed money too, and potentially have the option of taking over the petition, even in circumstances where the original petitioning creditor had been paid. One recent development, though, that we've been seeing, often that didn't happen until the advertisement had occurred. In the last 2 years, really, I started noticing it far more often that some of the credit referencing agencies, IT, is able to pick up as soon as a winding up petition has been issued against a company, almost immediately. And that can have the effect of a bank freezing the company's bank account and other creditors finding out far earlier than they used to do. Often it might take 2 months after the petition had been issued before it was advertised ahead of a 1 week before the hearing. Now that can happen virtually instantly. In some respects, it kind of blunts compulsory winding up petitions as a methodology of debt collection. Again, as we've said, they shouldn't really be used for debt collection purposes, because in the past, a creditor might say, well, look, you owe me this money, pay me or I'll advertise the petition. Clearly, and I'll advertise the petition, consequences of which your other creditors will find out and your bank will freeze your bank account. Now that the companies, that's happening virtually instantly, to the point whereby the person who's issued the petition may not have had it back to serve it, but before the company has been approached by people who've picked up on the computer systems or on the internet, in effect, that the company's been placed into that process.
So it can be catastrophic from a very, very early point, can't it?
Once your bank account has been frozen, you can't. Most companies can't trade.
Yeah.
Most trading companies, that is the end, actually. You can apply for interim injunctions to allow certain payments to be authorised, but the success rate of people once their bank account, people being able to sort of avoid being compulsory wound up in circumstances where the bank account has been frozen are few and far between. I've been involved in a few where we have been able to successfully rescue the company and avoid the petition, but it's expensive and it's difficult.
And you're relying on largely personal assets at that point, aren't you, to be able to do it?
You would need or a group company or some other connected parties prepared to lend the money. Borrow the money. I always get that the wrong way through, lend and borrow. If I'm giving you money, I'm lending and you're borrowing. Yeah. You do owe me a tenner, by the way.
Do I? I won't ask what for.
I've made that up just for a joke for this podcast.
Thanks. Finally,
yes.
Then let's talk about these are all going to be stressful positions for people.
Yeah.
They're going to be quite difficult. There might be a temptation to settle certain debts early. And there might be temptations, particularly if there are family ties or something like that, to try and get some of the assets out the way of the creditors, to do deals that might not exactly be in the best interest. They might be at a low value. It might be moving a piece of property out. It might be paying one debt over another one. What happens in those circumstances? Is that something that directors can do, or is that something
I think it's often something that we do see directors do, particularly in the compulsory situation where something's, they know it's going to happen and it's sort of against their will, is that they would try and transfer out an asset or try and pay the brother-in-law off who lent them 20 grand to pay last month's wage bill. So perhaps unsurprisingly, the law doesn't like that occurring, and because it's unfair. Why should the brother-in-law get paid his £20,000, whereas the other creditor down the road, the builders merchants, who's also owed £20,000, they're stuck with getting whatever the insolvency practitioner is able to recover. They get 5p in the pound. Brother-in-law gets £20,000. That's unfair, and the law recognises that, and will often call that what's known as a preferential payment, particularly here because it's made to a connected party, somebody you've got a connection to, and it's very broad definition of who a connected party is. If you do that, even within about 6 years of being insolvent, and you're insolvent at the time that's occurred, or in terms of you do owe people, you have got financial monies, financial pressures on your company, you're at risk of having that transaction set aside, and actually the insolvency practitioner saying to you and saying to your brother-in-law, I want that £20,000 back, that needs to be paid back. Transaction is set aside so that we can pay that money to the body of creditors as a whole. And all of the smart ALEC ways of selling something, buying something from brother-in-law, or paying something for all of those things potentially are vulnerable to an insolvency practitioner setting aside that transaction. Same goes for trying to sell some asset on the cheap. You allow brother-in-law to have one of the company vans for nothing, or at a song, again, that's liable to have under what's called the antecedent transactions legislation, which is part of the Insolvency Act. That's likely to be vulnerable as potentially a preferential payment stroke transfer of an asset, or a transaction at an undervalue. So, again, like with everything, I know that we're sort of like broken records here. That's where you need to get professional advice. You might have good reason why brother-in-law does need to be paid first. He might be your landlord, and if you don't pay him, he's going to close the gates. And that paying him, there's a good reason to pay him, as opposed to the builders merchants. In those circumstances, again, you need to obtain that advice, and the director who's got that professional advice will have, and indeed the brother-in-law will have the defence potentially when the insolvency practitioner starts to look at, and what they're duty bound to do, the events that lead up to the company going insolvent.
Okay. I think that rounds it all off. We've done a whistle-stop tour through insolvency and the various elements of it. All that's left to do, so thank you for watching, and join us next time.